Hello, we are delighted to welcome you to the final webinar in our four-part series in which we are looking at how you can resolve your construction dispute. And today we'll be focusing on litigation and court reform. For those who have participated in these webinars already, you will have heard us describe this series as something of a back to basics webinar series. We've looked at the main dispute resolution options, adjudication, mediation, arbitration, and today we're going to look at litigation. The law and the processes and procedures which support the upholding of the law are ever-changing and adapting to keep up with the wants and needs of those who use the system. It's always important to keep up to date with the very latest legal and procedural rules, as well as the best strategies and approach for participating in a dispute resolution process. For litigation, as we will see, now is an especially important time to be aware of quite radical changes in the court system in Scotland. I would encourage you to listen again and share with colleagues any of the webinars in this series. They have all been recorded and are available on our Vimeo site. Just before we begin, to minimise background noise, I've placed you all on mute. If you'd like to ask questions, please do so using the webinar chat function, and we will answer some of these at the end. I'm Ian Drummond, a partner in the Construction and Special Projects team specialising in construction and engineering dispute resolution based in Edinburgh, and I'm joined by Nathaniel Buckingham, a solicitor in my team and a chartered civil engineering professional by background. Both Nathaniel and I regularly advise on construction contract issues and disputes across a range of projects and clients, and even with the multitude of alternative dispute resolution processes available, court litigation is still very much a staple of our work. Our experience in that regard ranges from actions in the Sheriff Court through the various levels of the Court of Session, and we act for employers, contractors, subcontractors and consultants all across the full range of dispute issues, project types and contracts. And it's this core experience that helps to form the basis of our approach and strategic advice for litigations, and what we are going to share with you today.
Thanks, Ian. We will start today with a brief reminder of the background and options for litigation, looking at the different courts and processes available. Some of you may have been involved in litigation before, but it is important context to remember the background to the litigation process, particularly when we look at the recent court reforms and changes to the litigation process. We will then talk about the benefits and drawbacks of litigation. We will be comparing litigation with the alternative dispute resolution processes we have discussed so far in this webinar series, and the part that litigation can play in your range of options for resolving construction disputes. Sometimes litigation can be the preferable option strategically. We will then share some of our tips and strategies for participating in litigation. Some of our tips will be relevant for whichever side of the litigation you are on, whilst others will be specific for one side or the other. Knowing the likely strategies of the other side can, of course, be itself very useful. Unlike some of the newer dispute resolution processes, court litigation is really a historic and ancient process. For as long as there have been laws governing our society, there have been institutions designed to uphold those laws and administer justice. In Scotland, the College of Justice, which now includes the familiar Court of Session and High Court, was established in 1532. But before even then, of course, justice was handed out by sheriffs, kings and lairds. The classical split in the law is between criminal law, which this webinar is not concerned with, and civil law, which encompasses all non-criminal law, such as commercial law, property law, etc. Construction disputes fall squarely within civil law. Scotland currently has two tiers of courts for resolving civil law disputes, though as we will see, these are becoming slightly blurred in the recent reforms. The lower tier is the Sheriff Court, which has a local geographical remit, usually centred on the old shires of Scotland and now grouped into regions too. The upper tier is the Court of Session, based in Edinburgh and with a Scotland-wide jurisdiction, and then of course onwards to the Supreme Court as necessary. The Sheriff Court and Court of Session have separate procedures for how litigations take place, though there are many similarities. Within each there are a couple of choices of procedure too, which I want to highlight. Both courts have a commercial procedure, with the Court of Session having 3 judges dedicated to commercial cases. Commercial cases benefit from a higher level of judicial management, meaning that the judge will push the parties on to the next stage rather than letting the parties determine their own litigation route and timescale. This requires a lot more upfront work from both parties, but usually results in a shorter litigation and often will facilitate an early settlement. This is because much of the case investigation and preparation is moved to earlier in the case, meaning that the strengths and weaknesses of each side's position become apparent earlier on. In ordinary non-commercial procedures, this stage is only reached much later on, which tends to result in more cases settling at the door of the court, i.e. when the full trial of evidence is poised to begin. Let's move on to the recent court reforms to bring everyone up to date with the recent changes to the litigation options and processes in Scotland. Over the last decade or more, it was felt by the legal community in Scotland that the Scottish courts had not adapted to the changing needs of litigants, particularly commercial litigants. The Court of Session particularly had an incredible backlog of cases, yet the sheriff courts were often avoided by commercial litigants, perhaps considering them to be a less desirable option. The Court Reform Scotland Act of 2014 was passed in November 2014, with various implementation dates for the reforms it contained. Lord President Gill, the highest judge in Scotland, hailed it as the single most important piece of legislation in the field of civil justice for over a century, and stated that the aim of the reforms was to maximise the efficiency and output of the courts. So this really is about making the courts fit for purpose and to serve the commercial litigants who use them. The biggest change, which came into effect from September this year, was to increase the exclusive jurisdiction of the sheriff courts from claim values of £5,000 previously to £100,000 now. Prior to this reform, parties with any level of claim, because £5,000 was such a low threshold, could effectively choose whether to litigate in the sheriff court or the Court of Session. Overwhelmingly, commercial litigations, even of relatively modest value, were advanced in the Court of Session, adding to the strains on that court. Now, though, parties with a claim up to £100,000 must use the sheriff courts. The result of this reform is that the sheriff courts will deal with a far greater number of claims and will effectively force many commercial litigants to use the sheriff courts when they may previously have opted for the Court of Session. It will also provide solicitors with the opportunity to advocate these claims in the sheriff court on behalf of their clients. Only advocates and solicitor advocates have rights of audience in the Court of Session, meaning that they are exclusively able to present claims in that court. However, all solicitors have rights of audience in the sheriff courts. Parties will still be able to instruct advocates and solicitor advocates to represent them in sheriff court litigation, but this will be optional, and parties can take advantage of the often cost-effective option of using solicitor representation alone. Sanction for use of advocates can be sought from the sheriff court only in circumstances where the case is particularly complex, and if granted, will allow the expense of advocates to be claimable by any party awarded expenses. On the application of any party, a sheriff can remit cases which would fall under the £100,000 limit up to the Court of Session if the sheriff considers that the importance, novelty or difficulty of the proceedings makes it appropriate to do so. The Court of Session has the option to accept such a remit or not, and it will determine whether the case being remitted is suitably important, novel or difficult to require to be heard in the higher court. So that is not any sort of loophole that can be exploited to get a Court of Session hearing, but it does at least provide for the opportunity for important and potentially groundbreaking cases still to be heard in the higher court.
There are changes to the appeal process too. Currently, a sheriff court decision can be appealed to the sheriff principal of the region, or in some circumstances can be appealed directly to the inner house of the Court of Session, which is the appeal division of that court. However, now a new Sheriff Appeal Court has been created, which from spring 2016 will hear all Sheriff Court appeals in civil matters. It has already started hearing appeals in criminal matters. So the only option for appeal from a Sheriff Court decision will in future be to the Sheriff Appeal Court, which will have Scotland-wide jurisdiction, and the decisions of which are expected to be used by all of Scotland's sheriffs when deciding future cases. So, In time, a body of sheriff court precedents will develop, which will avoid the regional precedents that had developed through sheriff principal appeals, which is what we've had up to this point. For actions which arise in the sheriff court for less than £5,000, there's a new simple procedure which replaces the current small claims and summary cause procedures. And under this new procedure, there are limited rights of appeal and only on final judgments. So it's intended that this new procedure takes a flexible approach, identifying the issues and trying to help the parties to reach a settlement. Hearing these cases will be a new branch of the judiciary called summary sheriffs who are to be appointed. The idea is that this type of lower-level civil claim litigation will be removed from the ordinary sheriff's role to allow them to focus on the higher value and more complex cases which are going to be coming into their courts. And these reforms are due to come into effect finally from spring 2016. Now, for the sake of completeness, I would mention a number of other reforms which won't necessarily be critical when it comes to construction disputes, but are worth being aware of as they may have a peripheral effect. The first is the creation of a Scotland-wide dedicated personal injury court. The second is that interdicts, in other words injunctions, granted by a sheriff will have an effect Scotland-wide, rather than being restricted as they are now to the geography of the sheriffdom. Also, there is a 3-month time limit for bringing judicial review actions, and that will have particular relevance for planning permission decisions which are sought to be judicially reviewed. Finally, further developments are underway or are planned. For example, restricting the use of expert witnesses in the sheriff court and the court of session, increasing the use of digitalised evidence, and updating the process of expenses recovery in other matters. These will be detailed in due course, and they are all intended to create a more modern, flexible and efficient court process in Scotland.
We'll now have a look at some of the benefits of litigation. The major benefit of court litigation for a dispute is the certainty and finality of a decision, subject of course to the court's appeal process. Adjudication decisions are only temporarily binding, and mediation of course relies on parties reaching an agreement. But if you take a dispute to a court, it will be determined and you can be certain of that result. And the appeals process within the courts isn't a major drawback to this benefit either, as the court appeals process is designed to be a safety net for higher decisions in novel or complex cases. Appeals are not allowed unless there are good grounds for doing so. Compared to mediation, you don't need the other party's consent to commence litigation, as it is a process which is available whether or not the other party wants it or thinks that it is appropriate. It is always available too, and we'll consider that a bit more when we think about litigation strategies. In England, the courts have for some time encouraged parties to consider and pursue alternative dispute options first, or face financial sanctions for not doing so. This approach has not been adopted in Scotland yet, and there is no indication as it will be. So for now, a party's option to litigate a real dispute against anyone at any time remains, subject to any contractual alternative dispute provisions there may be. Unlike adjudication, which, unless provided for in the party's contract, is only automatically available for construction contracts, litigation is available to everyone for any dispute. Although, of course, we are talking about resolving construction disputes in this webinar, the actual statutory definition of construction contracts, which underpins that right to adjudication, does have some limitations. There are a number of excluded operations, such as oil and gas drilling and extraction, surface and underground mining, assembly and installation of plant or machinery, and any associated and supporting structures where the primary activity is power generation, and also water treatment or in certain chemical, pharmaceutical, oil and gas and food and drink situations. So that's quite a range of exclusions, and if you have a dispute in any of those circumstances, you will probably consider it as a construction dispute, but as you would fall out with the statutory definition within the Construction Act, you may not have an automatic right to adjudication. However, in all circumstances, litigation remains an option unless the contract provides otherwise. The other major benefit is that a whole dispute can be decided through litigation. Although that is technically true of all dispute resolution processes, the reality is that it can sometimes be quite tricky to resolve whole, large, complex construction disputes by those means. Adjudication is supposed to be quick, rough and ready, and although time periods can be extended by the consent of both parties, a large and complex case would quickly grow to be a daunting challenge for any adjudicator, even if they are given the benefit of more time. Also, inevitably, it will be difficult for an adjudicator to get to grips with all the complexities of a large-scale dispute. That is why, in our adjudication webinar, we recommended using adjudication for discrete disputes, or to pick off smaller aspects of a larger dispute, such as an extension of time or loss of profit claim in a wider final account dispute. Mediation too can be practically daunting if there are too many issues on the table, and unless the parties are just simply focused on the numbers and looking to cut a deal, a complex dispute can be too cumbersome for mediation. Whereas litigation does allow a whole large complex dispute to be taken, and it would then be worked through in the court process. That would inevitably take time, and of course the more complex a case is, the more time it will take in the courts, but you will at least know that you can ultimately get through that to a certain decision on the whole dispute. Sometimes having a background in the technical subjects of the dispute is cited as an advantage for adjudicators or arbitrators over judges. However, today, certainly the commercial judges in the Court of Session are very familiar with construction cases and construction law, and of course are usually of considerable intellect and able to pick up the technical aspects very quickly. Finally, litigation can often still be used and seen as a show of strength to the other side. We noted previously that a drawback of mediation is its perception sometimes of being a soft option, a perception that is thankfully receding. Well, litigation has the opposite reputation, and that is that few would litigate given the cost, time and resource commitments of litigation unless they have some conviction that they have a good case.
The two major drawbacks of litigation are the costs and time involved. While costs are technically recoverable in litigation, in reality in Scotland only a proportion of costs are ever truly recovered, usually around 50 to 60% of actual costs. Normally speaking, a larger percentage than that is recoverable in proceedings in England and Wales. Now, there is the opportunity to ask the court in Scotland for a higher award if your case is particularly complex or novel, for example, but this is not automatic, and in order to do so, you have to demonstrate that there is a good reason why your costs are higher in order to recover more from the other side. Costs are also often only awarded at the end of the litigation process once a decision has been reached, although I should say that planned reforms are likely to change that situation. Anyway, that present position means that anyone pursuing or defending a case needs to have a sufficient war chest to cover these costs, at least on a temporary basis. And the length of time litigation takes will usually add to those costs. Litigation activity is at a lower level of intensity to that which is required in adjudication. Now, this can be a benefit, as it will not divert senior management time to the same extent or intensity. However, because it will take place over a longer period, higher costs will be borne. The time that litigation takes can also be a major drawback, as any significant dispute will likely take well over a year to get through to a final decision. Even the time taken to launch a litigation, which involves notifying the defender and allowing time for them to say whether they're going to defend the case or not, and to prepare initial defences, that is a longer period than the whole of most adjudications. There are some ways of mitigating this, for example by using the commercial court procedure and benefiting from judicial case management, but even in these circumstances the court process is still relatively slow. Parties also need to be aware that in litigation you are handing over control to a third party. That has benefits. An objective, dispassionate view of the dispute and the party's position is taken. But it can also be a drawback, resulting in parties themselves often feeling adrift from the process. Also, there is no room for a novel solution, as there is sometimes in mediation. The court will simply decide the merits of the case. Court litigation is a very public process too. Hearings are usually heard in public. Cases are sometimes reported in the papers and in legal journals. This can have a strategic benefit in some cases, as it can put pressure on the opposing party. However, you need to be aware that you can't control headlines. The press may see and take a different angle on the matter that is less favourable than you expected. If litigation seems to be the best way forward, but publicity aspects are a prime concern, then arbitration may offer the best alternative, although you would either have to have a contractual right to arbitration or gain the other side's agreement to arbitrate. Finally, it is unlikely that relationships between the parties will survive litigation. Mediation offers the best way of retaining a relationship, but even adjudication, dealing as it does with issues quickly, may not damage a relationship beyond repair, as litigation often does.
Before we look at our tips and strategies for litigation itself, we'll offer some thoughts on when litigation should be used. We noted earlier and in previous webinars that one of the most effective strategies for resolving construction disputes in our experience, particularly complex disputes such as a final account dispute, is to first use adjudication to deal with discrete issues or to narrow the issues between the parties, and then to seek a mediation to conclude the dispute. So where does litigation fit into that? Well, litigation can often be the background to these other dispute resolution approaches and can be used to keep pressure on the parties whilst these alternative avenues are explored. In a complex construction dispute, it is likely that both parties will realise that the dispute is real and needs to be resolved, but one side or the other may be slow in acting or considering how to resolve the matter, and of course the threat or initiation of litigation can assist with that. So litigation is often the last option parties consider if there is a complex dispute, as parties will know that it is likely to be a long, drawn-out and costly process. And so in that sense, it can sometimes become something of a default strategy, which is to be pursued when all other avenues have been explored. However, there are times when litigation is the preferred initial option. For example, a dispute where the party commencing the action does not feel that a compromise is available, such as just simply determining where blame lies for an event. In circumstances like that, parties may not be willing to compromise, as they may in a final account dispute, and they may just be looking for a final decision to be made one way or the other. Adjudication would be an alternative here, but a complex legal and technical issue may be unwieldy for an adjudicator, and the party may fear being caught out by the rough justice of adjudication if the arguments and technical aspects are not given a proper airing. Also, litigation is often an effective means of laying bare the strengths of your case and the weaknesses in your opponent's case, or indeed to flush out the strengths and weaknesses of either side's case. That can involve pursuing a litigation part of the way through, then exploring an out-of-court resolution once that stage is reached, possibly at mediation, and this is often a very effective strategy. One thing always to consider when deciding on your strategy is the question of prescription, because your right to make a claim will have time limits at common law, contract, or both. Therefore, there may be circumstances where you need to commence a litigation to interrupt prescription and then pause while other approaches are worked through to decide whether those will resolve the dispute or whether the litigation will need to go ahead. Adjudication is not effective in stopping prescription, and whilst arbitration can be, it is less certain.
So let's now look at some of the important strategic and practical approaches to litigation. The first is to construct your litigation team, choosing your solicitor and your advocate or solicitor advocate if appropriate. You may also need an expert witness for a technical aspect or a quantum specialist. These people need to be right for their own task, but also need to work well together, particularly if a case is going to go on for a number of years. Also, experts should not only be expert in their field of experience, but also competent at writing reports and appearing in court. If you are the side wanting to launch a case, then you have the advantage of choosing when to launch it. Use this advantage and carefully choose when to raise proceedings against the context of other ongoing discussions. Be careful that the time is right, as commencing a case when discussions are ongoing may make the other side walk away from the discussions. But equally, if discussions about resolution are progressing slowly, then a court action being raised may prompt action before the expenses of litigation start to bite. You must wait until at least you are certain that you have a statable case. You cannot raise unfounded or speculative actions without some basis for the claim being made. But you don't have to have worked out your entire position on everything before commencing, as investigations, expert reporting, etc. can all continue during the early stages of litigation. If you think a court action may be raised against you, whilst it never hurts to prepare at that stage, the need to do so is less urgent than, say, in adjudication, as the court timescales generally provide a reasonable and sufficient time for a defender to conduct investigations, instruct experts, and then prepare their court pleadings. For either party, you should consider whether you have all of the documentation needed to pursue or defend the case. The court process has mechanisms for the recovery of documents necessary, and these can be valuable if you do not have your own good records. This isn't an option in adjudication, by contrast, where you are reliant on the records and documents you have, or those which the other side choose to display, and they don't have to display anything unfavourable that they think that you may not have. As a defender in litigation, it's a good idea to put in all possible lines of defence into your defences, including potential counterclaims and set-offs. And defences in court pleadings can be properly constructed with a number of alternative arguments. This is normal in pragmatic practice, and the court and judge will not consider this to prejudice any primary position adopted. If at any stage either party realises that their position is weaker than initially thought, then they can consider carefully, or they ought to consider carefully, whether it is worth seeing through the litigation process to a conclusion, or whether it is better to negotiate a resolution in order to curtail the ongoing time and costs. The courts are comfortable with this approach, and indeed the court process allows for judicial settlement offers to be made, and these are called tenders in Scotland. These can be very effective, as they force the pursuer to seriously consider settlement, because if the pursuer rejects the tender offer, but then fails to achieve a higher court award, the pursuer will be liable for all the defender's expenses from the date of the tender, despite the pursuer's successful outcome. And we should note at that point that there are discussions ongoing as to the possibility of including a process for pursuers making formal tender offers in litigations, and that will be one of the reforms that is likely to come through in the next period. Finally, for those considering pursuing significant litigation claims, litigation funders now have a range of sophisticated litigation funding models which may assist in the funding of the litigation. These essentially turn a good litigation claim into a monetized off-balance sheet asset. The funder will want to return on its investment, obviously, but in doing so, it will take the risk and will remove the cash flow issue. Shepherd and Wedderburn are at the forefront of the litigation funding market in England and Wales, working with a number of leading funders, and we are seeing these funders now starting to take an interest in the Scottish market.
So we've now come to the end of the presentation, which we hope has been useful and interesting, and we still have a few minutes to answer any questions. If you haven't already done so, please type your questions into the chat box now. While you are doing that, I will take the opportunity to remind you that all 4 webinars of this webinar series have been recorded and are available on our Vimeo site to listen again or share with colleagues. A link is on the screen, and you will all be sent details of how to access this after the webinar. In January, we will be running a webinar mini-series focusing on the key case law updates from 2015, firstly on court litigation on Wednesday the 13th of January, and secondly on adjudication on Wednesday the 3rd of February. Full details of how to sign up can be found through the link shown on screen. Finally, and slightly further ahead, we will be hosting 2 spring breakfast seminars in early March, again full details of which can be found through the link shown on screen. I would encourage as many of you as possible to sign up to the next webinar series, and also to attend and take advantage of the interactive nature and the networking opportunities presented by our breakfast seminars. Okay, now we have a question regarding tenders, which is at what stage in proceedings are tenders, which we've just spoken about, allowed to be tabled? Does it need to be before the first day and before the court proceedings begin?
The answer to that question is tenders can be made at any stage of the court proceedings, really right up until the day of the judgment. Now, clearly there are strategic decisions to be made as to the timing of tenders, because the earlier that a tender is made, then the more protection it gives in respect of expenses, remembering the point that we made that if, as a pursuer, i.e. a claimant, if you don't beat the sum that's been tendered by the defender, and then you'll be liable for all expenses after the date of the tender. So clearly, the earlier the tender is made by the defender, the more protection that gives the defender. But the counterbalance to that, obviously, is that a defender will need some time to investigate his position and to consider the strengths of the pursuer's case before he can be confident that the level of tender he's going to make is at the correct amount.
Yeah, we've had a couple of questions which may link together, actually. One is whether we've got to generally see a preference between the commercial court or the ordinary court in terms of raising actions in the court of session. And we've also had a question in relation to prescription about how long the courts are likely to allow proceedings to be paused while you pursue alternatives. Our preference generally is the commercial court. I think for most litigants that we deal with in construction disputes, the commercial court has lots going for it, primarily the judicial case management, which pushes parties forward and pushes the case on. However, interestingly, when it comes to prescription, the prescription question and how long you can pause proceedings, the commercial court is much less sympathetic to the pausing of proceedings. So if you raised an action in the commercial court, they really do want you to push that forward and move forward with your case there and then, and they're not hugely sympathetic to pausing while you look at alternative dispute resolution methods. So in circumstances where you are just looking to pause or to deal with prescription or to interrupt prescription and to look at alternative settlements, then it would be probably best to launch your action in the ordinary court. And I would say at this point, you can transfer from the ordinary court up to the commercial court at any time, and vice versa. You would simply apply to the court that you're currently in for that transfer. Now, if you launch your proceedings in the ordinary court, then the commercial and you ask to be transferred, then that's subject to the discretion of the commercial judges. But if your circumstances are that you've raised an action to counteract prescription, sought alternative dispute resolution, but have failed and want to continue with your action, but it's clear it can go forward as a commercial action, then the commercial judges are likely to accept it. So there are, depending on the scenario, both have their merits, but generally our preference would be for the commercial court.
Okay, that's probably all we have time for. So all that remains for me to say is thank you very much for joining us, and we do hope you found this webinar and this series of webinars informative and useful, and we look forward to welcoming you to our future webinars and our evening seminars, and further details on those will be out fairly soon. So thank you very much for joining us.